My Lords, good morning.
Morning.
I'm Professor Zachary Douglas QC, appearing for the first, second and third appellants, together with Oliver Jones. Stuart Catchpole QC and Philippa Webb appear for the respondent. I'm going to structure my opening submissions into 8 parts. The first is the significance of the fact that this case involves a claim to immunity from execution rather than immunity from adjudication. The second part, the proper approach to interpreting Section 13.2 of the State Immunity Act, which deals with immunity from execution. The third, an analysis of the common law cases on control and interest, which we say is the test for the requisite link between the state and property for the purposes of Section 13.2. Fourth, a reference to the UN Convention on Jurisdictional Immunities as confirming that the common law approach is consistent with customary international law. Fifth, an analysis of the Republic of Turkey's control and interest in respect of the shares that Botaş, the first appellant, formerly owns in the Jersey companies TPIC and Bill, the second and third appellants, against the background of the tests coming from the common law cases. Sixth part, a critique of the judgments below on the manner in which the Jersey courts approach the test for control and interest. Seventh, a response to the respondent Tepe's primary case on Section 14 of the State Immunity Act. And then finally, the 8th part will be a brief account of the sovereign purpose to which the shares are being used. So first, what's the significance of the fact that this is a case involving a claim to immunity from execution? Well, the distinction between immunity and execution is not always easy to apply, but there's no doubt in this case. Botaş and Tepe submitted disputes arising out of 2 different contracts to ICC arbitration. The seat of the arbitration was Paris. Awards were rendered in favour of Tepe. There were challenges to the award in the Paris courts. And at that point, the adjudication of rights and obligations under the contracts and the awards came to an end. Then Tepe sought to enforce the awards against Botaş's shares in TPIC and Bill in the courts of Jersey. And the question now is whether there's a legitimate claim to immunity in relation to the execution of the awards against those specific assets. So we're squarely in the territory of immunity from execution, and this is common ground. But an unusual feature about this case, my lords, has been the fact of divergent views about which provision of the State Immunity Act actually applies to the assertion of immunity in this case. The Royal Court of Jersey, at first instance, considered that Section 6.4 of the State Immunity Act is applicable. The Court of Appeal held, and both parties now accept, that this was wrong. And we say this is a fundamental error because Section 6.4 is concerned with immunity from adjudication rather than immunity from execution. So the Court of Appeal correctly held that Section 13.2b is applicable, and that provision, along with subsection 4, that deals with the state's immunity from execution against property. But, my lords, the Royal Court's mistake infected the Court of Appeal's approach for the reasons actually identified by the respondent in its written case, paragraph 37. There's no need to turn it up, but I'll read it to you. Although they say this, although the Jersey Court of Appeal concluded that the appropriate section to be considered was Section 13.2b rather than Section 6.4, that made no practical difference because the Jersey Court of Appeal equated the test under Section 6.4 with the requirements of Section 13.2b. Now, we agree that that's what the Court of Appeal did, but we fundamentally disagree about it making no practical difference. The reason why it's wrong to proceed under the assumption that the tests in Section 6.4 and 13.2b are the same is because the former deals with adjudication and the latter with execution. Customary international law and the State Immunity Act take a more robust approach to immunity from execution. than for immunity from adjudication, because the execution of judgments or awards against state property constitutes a more immediate and direct interference with a foreign state's sovereignty than simply being made party to adjudicative proceedings. And we see this reinforced at the highest level. If we turn up the International Court of Justice's judgment in Germany and Italy, and this is at the appeal bundles at volume 5, tab 35. Page 1316 of the bundle. And it's paragraph 113 of the judgment.
Is that 1316? Is that the electronic page?
I hope it's the same, my lord. It's the
What paragraph are you on?
113.
That's the right.
Of the Court of Appeal. Well,
It seems that the electronic pages may be different. To the
well,
bundle.
the reproduced record is just page 67. Is that right?
That's the that's the reproduced record.
In volume 5,
rather than
I'm
the
sorry.
authorities.
In the hard copy, it's 1316.
That's correct. Yeah.
Have you got an electronic number?
I don't, my lord.
Oh dear.
It's the same, I think, in the authorities bundle.
That's what it ought to be.
Maybe it's separate.
Quite commonly,
actually.
isn't it?
It may be that you're referring to the record below rather than the authorities bundle.
It may be separately paginated.
Sorry, Professor Zeffie, you haven't helped me on this. It's authorities bundle.
Number 5.
Tab 35.
Tab
Got it.
35.
Thank you very much.
I mean, there's a good deal of English authority for this proposition.
I found it.
There is,
Not
indeed.
least the
that is-
Colombian embassy case.
Yes. No, indeed, my lord.
I mean, one
This
has to be
is certainly
careful
not
about-
something which is unique to the pronouncements of the International Court of Justice.
One has to be careful about the international authorities because the British Act is not in all respects consistent with either the draft convention or customary international law.
Indeed, my lord, and we will perhaps come on to differences, if it in fact matters, in this appeal. So at paragraph 113, this is what the court says. Before considering whether the claims of the applicant on this point are well-founded, the court observes that the immunity from enforcement enjoyed by states in regard to their properties situated on foreign territory goes further than the jurisdictional immunity enjoyed by those same states before foreign
This is
courts.
fundamental, isn't it? But what you have to ascertain is what the position is in respect to the particular issue before you. I mean, if you want to get the general principle, it's obvious from reading the State Immunity Act, isn't it, that there are restrictions on enforcement which apply on top of the jurisdictional restrictions.
Indeed, my
But
lord.
it doesn't mean say that in every area, for example, the concept of property is more restricted when you come to enforcement, or is the same as the concept of property when you're dealing with grounding jurisdiction. You have to look at the particular wording and work out what is sensible.
You have to look at the particular wording, but you also have to bear in mind the animating idea behind the Act, whether we're talking about the State Immunity Act or the UN Convention, which is the restrictive doctrine. So the concept of property in a particular provision serves a functional purpose. And that functional purpose, when we're talking about immunity from execution, is to protect assets which are being deployed for a sovereign purpose from execution. And sometimes, and it's a point that I'll get to in a moment, but sometimes the drafting technique camouflages the principle.
Well, I think, obviously, I take the point, but it's usually quite dangerous to construe particular statutes by reference to general preconceptions.
Perhaps that's true, but I don't think there can be any serious doubt that the State Immunity Act does embody a restrictive doctrine. And when it comes to the nuts and bolts of how we apply a particular section, in my submission, we need to bear in mind the animating idea. But I'll come on to more concrete examples in a moment. But perhaps I won't then quote to you the entire paragraph 113, but it simply makes the point that immunity from execution is broader than immunity from adjudication, and these different types of immunities need to be considered separately. Nothing particularly controversial there. And the reason why, and again, I doubt this will be controversial is given by some of the academic authors that we refer to. And just to take one, in our printed case at paragraph 29, paragraph 30 rather, we quote from the recent edition of Brownlee, which was edited by Judge Crawford, and he says this: the transition from absolute immunity towards a restrictive doctrine has been slower to take hold in the case of immunity from execution against property than from immunity from adjudicative jurisdiction. The exceptions to immunity from execution are narrow in scope, and courts tend to respect the discretion of states in claiming that the property at issue is used for public purposes. This is understandable, given that measures of constraint are much more intrusive on state sovereignty than mere exercise of declaratory jurisdiction by a foreign court. State property used for public purposes is not the same as property of private persons. So in this respect, my lords, we quibble with the Court of Appeal's statement at paragraph 116 of the judgment. I don't think we need to go there right now.
The statement you've just read is based implicitly on a concept of what state property is. It's unlikely that it would have been phrased in exactly that way if state property had the very broad effect that you seek to give to it.
My lord, my submission will be is that one has to give effect to that concept by reference to the functional purpose that concept is serving. The functional purpose that that concept is serving is to determine those situations when property is being used for a sovereign purpose and ensure that that property is not being enforced against.
Even if it's not property of the state?
That begs the question of what property of the state is. But in our submission, the test
so your submission is that all property which is used for sovereign purposes by whoever, whether a state or not, is immune from execution of a judgment against its true owner.
That's correct, my lord.
You couple to that a very wide concept of sovereign purposes, because on the face of it, a holding in a commercial company is not necessarily held for a sovereign purpose. You'll come to that at some point. I'm going
to come to that, my lord. But the fundamental point, though, is that it would be unusual, and we would advise and submit that the court should be very careful to go down this route. It would be unusual if there could be no dispute that the asset is being used for a sovereign purpose, and yet the precise relationship between the state and the property was deemed not to be sufficient for that property to pass that first hurdle. I mean, suppose you've got a state enterprise that manufactures fighter jets, as many do around the world.
Manufactures what?
Fighter jets, military hardware of some sort. Now, it may well be that formal ownership is held by the state enterprise, and it may well be that the state enterprise, if it enters into a transaction in relation to those fighter jets, that there won't be immunity for adjudicative purposes. But when it comes to immunity from execution, one would expect that the state would have a sufficient control or interest in that asset, the fighter jet, to ensure that it couldn't be enforced by a private creditor.
Why would one expect that if it's not the state's property and indeed has been deliberately placed in an entity which is, for the purposes of the Act, separate?
Because it wouldn't be entirely satisfactory for private creditors to run off with military fighter jets, I would submit. So that
with military fighter jets in operational use, I can see, but with the backstock of the company, it's a completely different situation.
Perhaps it is, my lord, but that would go to whether or not it's actually being used for a sovereign purpose. If it's backstock, it may not be. But if it's been flying around at air shows, for example, and is in full operational use, one would hesitate, I suspect, before concluding that a private creditor should get their hands on it. So, my lords, we would quibble with the Court of Appeal's statement. And you see this at different paragraphs of the judgment, 116, 120, 122. They say that the threshold for immunity from execution against property is at least as high as for immunity from execution. We quibble with that because it's not at least as high. Immunity from execution affords more protection. And this is demonstrated by the way the courts have to approach each type of immunity. When we look at immunity from adjudication, we look at the nature or the character of the acts relating to the transaction. When we look at immunity from execution, we look at the purpose to which the property is being used. So there's a fundamentally different approach that we take to the different types of immunities. And again, the commentators make this absolutely clear. We've quoted from Fox and Webb at paragraph 40 of our written case, where they say, Section 13.4 reintroduces the purpose test for attachment, which the exceptions to adjudicative of jurisdiction abandoned in favour of a nature of the act or of proceedings test.
Which paragraph was that again?
That's at paragraph 40 of our written case.
14, yes.
And that's once it's established that it is the property of the state. Once it's the property of the state, you then inquire what the purpose for which it's used is.
Well,
But your submission is you look at the purpose for which it's used to decide whether it's the property of the state.
it's not quite my submission, but I would submit that those two provisions need to be read holistically, because the principle of the restrictive doctrine is that it's only assets of the state which are used for a sovereign purpose that are protected. So to take an easy example of the nature versus purpose test, a transaction involving the sale of Stinger missiles may well fall outside immunity from adjudication because the nature of that transaction is a private law contract and private law parties can enter into it. But an attempt to enforce the judgment against those Stinger missiles may fail by virtue of immunity from execution if those Stinger missiles, as you would expect, are being used or intended to be used for a sovereign purpose. So, in summary, the Royal Court was wrong to say that this was a question of immunity from adjudication. The Court of Appeal was wrong to say that the test for immunity from execution against property was in substance the same as immunity from adjudication. So what's at stake in a case involving a claim to immunity from execution? These are very obvious points, but the consequences of a decision upholding immunity is that a particular asset in its current or intended use is not available to satisfy a private debt. And I say present time because if the use changes, then the protection may well be removed. So long as if the use changes and it's used for a commercial use, then it would no longer attract protection. And it's another very obvious point, but if the claim to immunity from execution is upheld, it doesn't somehow interfere with the validity of the underlying debt. The petitioners are free to try to enforce that elsewhere against another asset, and that's exactly what's happening in this case. Tepe has gone to the courts in Turkey and are seeking enforcement there. At this instance, before you today, you're actually not in a position to uphold the immunity because the most important part of the test, which is whether or not these shares are being used for a sovereign purpose, is not before you. And it's not before you because despite full submissions on this point before both courts declined to make findings on that issue. And for reasons that I'll come to, that's not entirely satisfactory. So the choices today are either whether you allow the appellants to proceed to the next stage of the inquiry, whether or not the shares are being used for a sovereign purpose, or put an end to that inquiry and declare that the shares can be enforced immediately. And of course, if that's the end of the road, then any sovereign use that these shares are being used for will come to an end as well. And all this in circumstances where you don't have the benefit of any findings on this particular issue. So I'll move to the next part. What's the correct approach to interpreting Section 13.2 of the State Immunity Act? Now, our submission is that it's sections 13, subsections 2 and 4 that apply. That's the conclusion of the Court of Appeal. The respondent's primary case is that Section 14 applies, but it accepts that if it's wrong on that, then the correct section is Section 13. And I'll return to that case in detail towards the end. Now, before we dissect Section 13 of the State Immunity Act, it's worth remembering Lord Diplock's critical but fair observation in the Alcom case concerning what he called the convoluted style of draftsmanship of the Act, which provided for exceptions to exceptions, which have the effect of restoring in part an immunity which some other subsection would appear to have removed. And this encapsulates, we say, the difficulties with section 13. And of course, it would be helpful if we had this in front of us. It's at volume 1, tab 1 of the authorities bundle. And 13.2 reads, subject to subsections 3 and 4 below, and then it's B that we're concerned with, the property of a state shall not be subject to any process for the enforcement of a judgment or arbitration award or an action in rem for its arrest, detention or sale. Then we skip to 4. Section 2B above does not prevent the issue of any process in respect of property which is for the time being in use or intended for use for commercial purposes. Now we say that those two subsections have to be read holistically to appreciate the underlying principle in relation to immunity from execution, and the principle is simply that the property of the state that's in use or intended for use for sovereign purposes is immune from execution. And that's the restrictive doctrine of state immunity as it's applicable to the execution of property. Now, the reason why that uncontroversial principle is slightly camouflaged by the drafting of section 13 is that subsection 2b starts off with what looks like the absolute doctrine. It looks like a blanket immunity from execution conferred upon all property. And then when one gets to subsection 4, that one understands that there's no such blanket immunity because any property of the state that is in use for commercial purposes won't enjoy immunity. So it's tempting, given that form of drafting, to make statements like state property is prima facie immune from execution, but that only serves to obfuscate the actual principle at play here, which is only property in use for a sovereign purpose is immune. And of course the policy behind that is to ensure that there's no disruption or interference with the sovereign functions exercised by the state. Now, Lord Sumption made this point about distinguishing between a drafting technique and a principle of law in the Ben-Khabush case in relation to the State Immunity Act and the Convention. I propose to go to that. It's at volume 4, tab 23.
Page. Page, please.
And it's page 994 of the bundle.
Thank you.
Is it the same, my lord, as the electronic?
Yes,
It is.
the problem was that a composite bundle was very helpfully supplied with a completely different pagination for the authorities. So I'm, of course, reverting to the authorities bundle, but it now works.
Now, the issue here, in a nutshell, was whether customary international law, the State Immunity Act and the UN Convention somehow embodied the absolute doctrine and then just simply created exceptions to it, or whether both in substance gave effect to the restrictive doctrine, and that should somehow play a role in interpreting the particular tests for immunity. And so you see at paragraph 37, the Secretary of State, in his submission, state immunity is absolute unless the case is brought within an internationally recognised exception. And skipping a sentence or two, the rule of customary international law is that a state is entitled to immunity only in respect of acts done in the exercise of sovereign authority. That's the restrictive doctrine. Lord Sumption says that it's true that the State Immunity Act adopts the drafting technique of starting a presumptive immunity subject to exceptions. But then at paragraph 39, he says, I don't regard these considerations as decisive for the present issue. Then he says this about the UN Convention, which I would submit is precisely the same in relation to the State Immunity Act. It says, in the first place, it's necessary to read the grant of immunity in Article 5 of the United Nations Convention, together with the exceptions which follow as an organic whole. The exceptions are so fundamental in their character, so consistent in their objective, and so broad in their effect as to amount in reality to a qualification of the principle of immunity itself rather than a mere collection of special exceptions. And secondly, it's important when doing this to distinguish between a drafting technique and a principle of law. My lords, the essential point here is that no normative consequences follow from the mere characterisation of property as property of the state in the context of the restrictive doctrine of sovereign immunity, which is embodied in the State Immunity Act and in customary international law. Status, you might say, doesn't matter anymore. The conferral of immunities takes a functional approach now. In other words, it's not the status of the property as property of the state that is important, it's the use to which that property is being put. And one can contrast that with the absolute doctrine, where the status of the property was all important. If it was the property of the state, then immunity automatically followed. But that's no longer the law. So the concept of property of the state for the restrictive doctrine and for section 13.2b has no other purpose than acting as a gateway to the heart of the matter, which is the question of whether the property is being used or intended for use for a sovereign purpose. And that's the heart of the matter because the policy behind the rule is not to protect property as state property, it's to protect state property as state property being used for a sovereign purpose. So, my lords, I would make 5 points in relation to this general principle. The first one is this: the judgments below are replete with statements to the effect that if there were to be a finding that Botaş's shares in TPIC or BIL are the property of the state of Turkey, then they would enjoy immunity. That's wrong. A finding that the shares are the property of Turkey simply triggers an investigation as to whether or not they're being used for a sovereign purpose. My lords, I'd like you to take just one example. There are actually 9 of them, but I'll take you to one. So there's no slip of the pen. It's on the record, rather than the authorities bond, on the record at volume 1, tab 9, page 191 of the bundle. Paragraph 184. And at this point in the judgment, they're looking at the various Turkish laws and decrees which the Republic says allows it to control the shares. And this is one of the points they make. They're talking about the public procurement law. But then they say this halfway down the paragraph: accordingly, if that were sufficient, it would mean that the shares in all subsidiaries of any Turkish state enterprise would be the subject of sovereign immunity. And that seems to us to be wholly inconsistent with the principles underlying the Act insofar as concerns separate entities. Again, that's wrong. It doesn't entitle them to state immunity. It entitles them to nothing. The determination that it's state property, the State Immunity Act, has no normative consequences until you move to the next stage of the test. So what they're doing there, my lords, is they're setting up a floodgates argument. But that floodgates argument is entirely neutralised by bearing in mind that we're only at the first stage of the test. And you see the same thing repeated, the same floodgates argument repeated at paragraph 180, 181, 185, 186, and it goes on and on. The same mistake being repeated over and over again. And that had an impact on the Court of Appeals judges because they adopted these findings, and therefore the floodgates argument. A second point in relation to this general theme is if the status of the property as property of the state were to be sufficient to attract immunity, as it would be the case under the absolute doctrine, then the courts would have to be very anxious to ensure that a narrow concept of property of the state should be maintained, because otherwise it could be the cause for injustice to private creditors. But under the restrictive doctrine of state immunity, with its emphasis on protecting sovereign functions rather than the sovereign status, there's no mischief, my lords, in casting the net wide at the first stage of the analysis, because unless the property of the state is used for a sovereign purpose, no immunity will attach. Third
Isn't
point.
that a rather incongruous submission in relation to the historical development? You're saying that we no longer need to worry about limiting the concept of state property. It may have acquired a wider meaning than it had under the old law. The general trend has been to limit state immunity, not to expand the concepts used.
My Lord, there certainly hasn't been a general movement to expanding immunity from execution, as we saw from the quotation from Brownlee. This is where states have been more anxious than in other areas to ensure that there is adequate protection. But I'm not saying that we cast the net so wide that it includes anything. As I'll come on to in a moment, the net needs to be cast wide enough so that the function that this test needs to perform, which is to protect assets being used for a sovereign purpose, the link between the state and the property to serve that purpose is wide enough to ensure that those types of assets are protected.
Effectively, you're saying that we can forget about property, and anything which is being used for a sovereign purpose is immune.
My Lord, that should be the principle at the end of the day.
Well, it's not how the Act is framed. The Act is quite clearly introducing a two-stage, a two-process test. You inquire, is this the state's property, whatever that may mean, you'll help us on. And then you inquire, if it is, what is its use?
My Lord, the test in our submission has to be wide enough and no wider than allow... what does it mean for a property to be used for a sovereign purpose? It means that the property is being subjected to sovereign powers. So the test has to be simply wide enough to ensure that when the property is being subjected to sovereign powers, that's good enough to satisfy control, that's good enough to satisfy the common law test as it stands anyway, and then you get to the right decision.
So you don't, in fact, attach any independent significance to the question whether it is the property of the state once you've decided it's being used for a sovereign purpose.
My Lord, this is
that question has been answered for you.
My Lord, this is my third point, and that is that the decision that property is property of the state for 13.2b in the context of the first part of the test has no proprietary consequences. As I said, it doesn't have any normative consequences at all until an answer is given to the second part of the test.
It's a precondition.
It's a precondition.
For the operation of the whole of the rest of the section.
Precisely, my Lord.
So it's rather critical.
It's critical, but we have to bear in mind the second part of the test to make sense of the first. That's all I'm saying. So what I'm saying is there's nothing incongruous about the statement that a certain asset is owned by a separate entity as a matter of corporate law, as a matter of property law, but for the purposes of the law of state immunity, it's considered to be the property of the state. There's nothing incongruous about that situation.
So on a different point, can you give me a reference to the statement of facts, which I...
Statement of the agreed statement of facts?
Yes.
It's in a separate little bundle.
Oh, right. That explains why I can't find
It's
it.
a thin one. That's all I can say about it, I'm afraid.
I've got it. Thank you very much.
So to put this point another way, there's actually no justification for applying the law of property to the question of whether a certain asset is the property of the state for immunity purposes. Because in applying the test, my lords, the court is not adjudicating upon competing proprietary claims to an asset. It's determining simply whether there's a requisite link between the state and the property to move to the next stage of the test, which is whether or not the asset's being put to a sovereign use. And as we'll see, the common laws, by implicitly at least, has got there, has recognised this point by insisting that the concept of state property should not be viewed through the lens of English property law in all its technical splendour, as we'll see. Fourth point. Once the concept of the property of the state is put in its proper context, which is a gateway to the further step in the analysis, then the proper approach to interpreting it comes into view. I've already alluded to this. For what does it mean for property to be put to a sovereign purpose? It means that it has to be subjected to sovereign powers. All sovereign powers emanate from the state. So it follows that the state must have a sufficient interest in or control over the property in question, so it can be subjected to the sovereign powers of the state. In other words, given that the concept, the property of the state, serves a functional purpose in the restrictive doctrine of immunity, which is to protect public property being used for sovereign purposes, we say that that functional purpose must inform the approach to interpreting the concept. And again, once again, the common law cases reflect this point, because from the Christina onwards, as we'll see, the test is centred on whether or not the state has an interest in or control over the property.
So those are cases on adjudication.
Most of them are on adjudication, although all the shipping cases are hybrid, obviously, and they deal with adjudication and execution. But we'll come on to those in a moment. The rest are, but you're quite right, my lord, the rest are about adjudication.
When in reality, the shipping cases are about adjudication, aren't they? Just in the old days, it was thought that you could separate the ship from the state.
My lord, strictly speaking, they applied the two different immunities. They set out the two different immunities and they applied them both. And they said that both were implicated by an attempt to arrest the state.
I mean, it's only hybrid in the sense that an action in rem
Is in reality an action.
well, it's in reality an action in personam. It's simply a procedural preliminary to exercising a personal power. And it was because of a confusion on that point that the Christina needed to be decided at all.
My lord, that's correct. But of course, once you have the judgment on liability, you've got the ship sitting there that can be then executed against.
Well, execution may be a consequence of an adjudication against the owner of the ship, but that's a different point altogether.
But I think that's what's implicit. We'll come to the case, but I think that's what's implicit in what they're saying, that because you have the ship in front of you that can be executed against if liability follows against the state, then potentially execution immunity is in play as well. But the statements of principle in those cases certainly address both immunities.
It's quite interesting, we'll come to it in due course, that the language of the statute deals with the position in relation to ships and adjudication differently from the language in relation to execution.
My lord, this is true. If one looks at Hansard, I'm not sure one is permitted to in the circumstance.
Have you laid the groundwork for that?
No. But all one gets from this, and we can see this from statements, many judicial statements over the years, that it was a complete mess, is the way it was drafted. There was no deliberate, conscious decision to use particular language in one section and not the other. I mean, if we go to 14 subsection 2, as we will, of course, the law is at the moment that the two limbs of that section are tautologous. That's the law of Gulf in Kuwait Airways. But as I submitted before, the courts in our submission should be very reluctant to interpret the concept property of the state narrowly if the effect is that where property is being used for a sovereign purpose, it can nonetheless be attached in enforcement proceedings. And just to take a very straightforward example, the attachment of a building that's formally owned by the foreign state may cause no interference with sovereign functions at all if that building's being leased on a commercial basis to commercial tenants. But where the foreign state only has a much lesser interest in that building, leasehold or otherwise, the interference could be very serious if the building's being used as the foreign state's consulate. So in other words, the nature of the proprietary interest is not really what matters here. It's the use to which the property is being put. Fifth point in this series is that given the concept of property of the state is purposively intertwined with the question of whether that property is being used for a sovereign purpose, it doesn't make a great deal of sense to be dealing with one part of the test in isolation from the other. Now, as I've said before, we've reached that point procedurally because both courts below declined to make findings on that issue. And we submit that that does put us in a more difficult position because the reality is that a court is more likely to find that a state exercises control over an asset if the court has sight of the evidence concerning how that control, in practice, underpins the sovereign asset to which the sovereign's purpose to which the asset's put. And we'll come on to that purpose towards the end. So to summarise the 5 points. First, the courts below were wrong to reason on the basis that if they had held that the shares were the property of the Republic of Turkey, then immunity would attach to them. That was only the first step in the analysis. And that did make a substantive difference to the reasoning because they kept drawing upon the floodgates argument. Second, the restrictive doctrine of immunity attaches importance to the function for which the property is being used rather than the status of the property as property of the state. So no mischief is caused by casting the net wide in examining the link between the state and the property, because the property will only be immune from execution if it is actually being used for a sovereign purpose.
But that might be a very wide purpose, very wide category indeed. Well, let me give you an illustration. In wartime, ships, without being requisitioned, are frequently required to operate under Admiralty directions for the purpose of carrying stores of significance in war. Now, you say, I think it's implicit in your submission, that those ships, although they remain in every sense possessory and, as a matter of title, the property of their owners, are to be treated as the property of the state, because the Admiralty directions are a means of requiring them to be used for the benefit of the state.
Although that's precisely right, and that is the principle we
that
get
is
from
not
the Christina.
That's not a narrow category at all. It's an extremely wide category, because its effect is to extend the relatively narrow category of state property to anything which the law of the state may require, albeit perhaps temporarily, to be used for the purposes of the state. And I slightly jib at your suggestion that this is a way of narrowing or limiting it. It's actually a way of enormously expanding it.
My Lord, in our submission, that would follow from applying the test in the Christina. You would, that precise situation that you're raising would be covered by the principle as articulated in the Christina. So perhaps we'll come on to that test in a moment, but that would be our submission at this stage. But the point, my Lord, is that the finding that property is the property of the state has no normative consequences per se in the law of immunity. The third point was that the finding...
Finding that I think the question which would be raised against you is whether it... finding that it isn't property has normative consequences, and if it's a separate point, it would have normative consequences, because it would be attached. As in the courts below, it would end the inquiry. So
that's correct. If the finding at the first stage is that it's not state property, then it gets attached. But what I'm suggesting, my Lord,
yes, you're suggesting a holistic view.
Holistically,
yeah.
And it really shouldn't be the case that a court deals with one and not the other. My third point was that a finding that property is the property of the state for immunity purposes has no normative consequences in property law or in corporate law. And so there's no per se justification in applying those principles to the law of state immunity. As I said before, there's no contradiction in the statement that a particular asset is formally owned by a separate entity and yet the property of the state for immunity purposes. We're not applying property law to this question. Fourth point, given that the concept of the property of the state serves a functional purpose in protecting property that's being used for sovereign purpose, that functional purpose should inform the proper interpretation of that concept. Property can only be used for a sovereign purpose if it's subject to sovereign powers, so there must be a link between the state and the property by virtue of control or interest. Fifth point was that it's prejudicial to the state, at least, for a court to rule upon whether property is the property of the state without making findings in respect of the evidence relating to the sovereign use of the property, for the simple reason that a court is more likely to see control, the requisite control or interest, if the court is cognizant of how that control is necessary to the sovereign purpose for which the property is being deployed. So I turn now to the third part of my submissions on the cases on control. And we start with the Parlement Belge, and that's Volume 1, Tab 4, page 71 of the Authorities Bundle. And this case really just goes to the essence of what the immunity from execution is all about, rather than the link between the property and the state, because here the property was unquestionably owned by the King of Belgium. But at page 203, the facts are set out in Lord Justice Brett's judgment. The proceedings in Rem were brought against a ship called the Parlement Belge. It was a mail packet owned by the King of Belgium. No appearance was entered by representatives of the King, but the Attorney General of the UK entered a protest to the effect that judgment could not be entered against the ship because she was protected by sovereign immunity. You see at page 204 of the report, 78 of the bundle, the issue was formulated in the following way. This is the second paragraph down. The proposition raised by the first question seems to be as follows. Has the Admiralty Division jurisdiction in respect of a collision to proceed in rem against, and in case of non-appearance or omission to find bail, to seize and sell a ship present in this country, which ship is at the time of the proceedings the property of a foreign sovereign, is in his possession, control and employ as sovereign by means of his commissioned officers, and is a public vessel of his state in the sense of its being used for purposes treated by such sovereign and his advisers as public national services. Of course, the interesting thing about that statement is that it's absolutely clear that the court is alive to the restrictive doctrine, despite the sometimes academic or orthodox view that restrictive doctrine only started from Trendex. This case only makes sense if we look at if we understand it through the prism of the restrictive doctrine. And the rationale that's given for the immunity, you'll find at page 210 of the report, 84 of the bundle. And it's the rationale that I've already implicitly mentioned. It's about halfway down the page. He says, the public property of every state, being destined to public uses, cannot with reason be submitted to the jurisdiction of the courts of such state, because such jurisdiction, if exercised, must divert the public property from its destined public uses. That's a very, very modern summary of the restrictive doctrine of state immunity.
Well, it's not actually. It's derived from the suggestion, which first appears in decisions of the US Supreme Court, that the mere fact that a state owns property or has at any rate a possessory interest in it is enough to demonstrate that it's in use for public purposes, however commercial, so that if you use if the state uses a ship for the purposes of ordinary cargo service becomes ipso facto a sovereign purpose.
Well, my lord,
it's the very reverse of the concept of state immunity, which is why, as the Christina held, the Parlement Belge is authority for the absolute doctrine.
My lord, Lord Justice Brett, at the end of his judgment, goes on to consider an argument, and you see this at page 219 of the report, halfway down the page. But it is said that the immunity is lost by reason of the ship having been used for trading purposes. So he's considering the argument that if it is being used for trading purposes, the immunity is lost, and that would be irrelevant in our submission if the absolute doctrine applied. And over the page he says, well, yes, this mail packet does occasionally carry passengers and merchandise, but that's subordinated to the duty of carrying the mails. And he finds that because it's subordinated to the primary purpose of the ship, which is to carry the mail of the Kingdom of Belgium, then immunity is not lost. And as we'll see in the Christina, at least 3 judges of the 5 thought that this case made no sense unless it stood for the proposition that vessels used for commercial purposes did not attract the benefit of the immunity. But I go back to the principle that comes away from this case in relation to immunity. And he says this, Lord Justice Brett says this at the bottom of page 214 of the report, 88 of the bundle. The principle that to be deduced from all these cases is that as a consequence of the absolute independence of every sovereign authority and of the international comity which induces every sovereign state to respect the independence and dignity of every other sovereign state, each and every one declines to exercise by means of its courts any of its territorial jurisdiction over the person of any sovereign or ambassador of any state, or over the public property of any state which is destined to public use. Again, we would say that the caveat destined to public use is very much a reflection of a restrictive doctrine at play, even though it's 100 years before the State Immunity Act. So then, with that background, let's go to the Christina, which is the first case in the series, which deals with the necessary link between the state and the property for immunity purposes. And that's at the tab 7 of the same bundle. No, sorry. Yes, tab 7 of the same bundle. Now the facts are set out at 486 of the report, 121.
Bundle page.
121.
Thank you.
Here, proceedings in rem by a company claiming to be the sole owner of the ship, the Christina, wanting to have possession of the ship judged to them. The Spanish government asserted that they had an interest in the ship and claimed immunity. And the context was that the Spanish government had previously issued a decree purporting to requisition all vessels registered in the port of Bilbao, and the Christina was a vessel registered in the port of Bilbao. But the Christina was not in Spanish territorial waters at the time of the decree, the time it was issued, and we see this recorded in Lord Wright's speech at page 501 of the report, 136 of the bundle. So, second paragraph from the bottom says, it's also been admitted that the Christina was not in Spanish territorial waters from the date of the decree until the date of the facts alleged to constitute the requisition, when she was in British territorial waters. So the importance of that is that the decree could not have had the effect of vesting ownership of the Christina in the Spanish government. And that was conceded in the very next paragraph you see there in Lord Wright's judgment. The respondent government does not contend that it is the owner of the Christina, but says that it is, and was at all material times, in de facto possession of the Christina. Now, how did the de facto possession come about? Well, if we turn back a page, 499 of the report, 134 of the bundle, the possession came about because the consul, the Spanish consul in Cardiff, together with the new master that he had appointed, boarded the ship and broke into the former captain's cabin. That was how possession was taken in Cardiff. You see that about halfway down 499. So that factual background in mind, we can read the classic statement of Lord Atkin on the two types of immunity. That's backtracking to page 490 of the bundle.
And it was the impact of that the Spanish government had a right of exclusive possession under Spanish law.
My lord, why would Spanish law be applicable to this? The vessels in Cardiff, the decree has no extraterritorial
Because she was requisitioned on the high seas.
But requisitioned...
Under Spanish, she was a Spanish ship who was requisitioned under Spanish law while on the high seas.
Was it on the high seas? I thought it was at Cardiff.
Well, it went into Cardiff, but as I think you pointed out a moment ago, the actual decree took effect in relation to the ship under Spanish law before she entered UK waters.
I'm not sure that that's recorded in the report, but it may be in the Scottish case that followed it. But so you may be right. But But the important thing is that it was conceded that it could not have vested property rights.
Well, I think you'll find the facts are set out in detail in the Lloyd's report.
Lord's report.
60 Lloyd's report, page 147 and following.
My Lord, for our purposes, I'm content to proceed.
Yes, she didn't arrive at Cardiff until the 8th of July, and the decree was the end of June. So I suppose she must have been at sea.
She must have been at sea.
Would she have been, I mean, on that basis, she might be said to have been a floating piece of Spanish jurisdiction.
But it doesn't seem that that argument was run, because you see from that passage I quoted from Lord Wright's judgment, it was not contended by the Spanish government that they had any ownership interest in
No,
the
but
vessel.
that's because the decree didn't purport to vest the ownership of the vessel in the Spanish government. It merely purported to put it at the disposal of the legitimate government of the Republic, and to give it and the decree was to give the government control and administration of a marine transport, not ownership.
It was to give it an exclusive right of possession,
Exactly.
which is a possessory title.
Well, except that they took that possession arguably unlawfully by breaking into the ship. I mean, under what lawful basis could have they said, well, we're by virtue of the Spanish decree, which is not operating in relation to a ship in Cardiff, we're going to take possession of the vessel?
Well, I think the argument was that they were acting pursuant to a change in the right of exclusive possession, which had occurred on the high seas when the decree took effect.
Well, except that, of course, the original crew was on board the Christina when it came into Cardiff, and it needed an act of self-help.
It's a right of exclusive possession, which was simply being exercised by the Spanish consul in Cardiff.
That may be the case, my lord, but it was an act of self-help that took them into de facto possession, and it's de facto possession which is referred to in all the judgments. And one suspects that that's precisely why Lord Atkin and Lord Wright focused on control in addition to possession, because otherwise you might find that foreign states resorted to these sorts of acts of self-help a bit more regularly, which wouldn't have been exactly consonant with peaceful relations between states. So control was very necessary in extrapolating a general principle here. But anyway, the two immunities are set out in Lord Atkin's report, judgment, in page 490 of the report, 125. And he sets out the two different immunities. The foundation for the application to set aside the writ and arrest of the ship is to be found in two propositions of international law engrafted into our domestic law, which seem to me to be well established and to be beyond dispute. The first is that the courts of a country will not implead a foreign sovereign, that is, they will not by their process make him against his will a party to legal proceedings, whether the proceedings involve process against his person or seek to recover from him specific property or damages. My lords, that's the immunity from adjudication. Then he goes on with the second principle, and this is immunity from execution. The second is, they will not by their process, whether the sovereign is a party to the proceedings or not, seize or detain property which is his or of which he is in possession or control. And he goes over the next page to say that in a case of a written rem, in which the ship is arrested, both principles are broken. The sovereign is impleaded and his property is seized. Similar statements from Lord Wright. If we turn to page 501 of the report,
Page
136 of the bundle. And I've quoted the start of this passage, where the respondent government saying, this is the bottom of the page, that it doesn't own the Christina, but it says it's in de facto possession. It's not claiming any right under the decree, it just says we're now in possession, de facto possession. And therefore, without its consent impleaded by the writ in rem, claiming possession adversely to its actual possession. Such a proceeding, it contends, is inconsistent with its position as an independent sovereign state recognised by His Majesty's government. Now that's a claim to immunity from adjudication. And then you see in the next sentence, their claim to immunity from execution. It further contends that the action involved a claim to interfere with its right of direction and control, coupled with actual possession acquired by reason of the requisition. So even the Spanish government saying this may interfere with our right of direction and control. And he goes on, Lord Wright goes on to say what requisition means. He says the word requisition, while not a term of art, is familiar and has been constantly used to describe the compulsory taking by government, invariably or at least generally, for public purposes of the user, or probably means direction and control of the ship with or without possession. So His Lordship makes it very clear that this second principle of immunity relating to execution extends to situations where there is no possession, as Lord Acton had done as well. Now, both grounds were upheld by the court, and we'll get to Lord Wright's reasoning as to both at page 506 of the report, 141 of the bundle. So halfway down the report on page 506, he's first looking at the immunity from adjudication, and he says at the 4th paragraph, this ground would by itself be sufficient to entitle the respondent to succeed, that he's dealing there with immunity from adjudication. He then goes on to deal with immunity from execution. He quotes from the Parlement Belge, which of course is a case relating to execution. And then over at the top of 507, 142 of the bundle, it says, the appellants, while not contesting the general principle, have denied that it applies to the facts of the present case for various reasons. In the first place, they have relied on the fact that the Spanish government had no property in the sense of ownership in the Christina, whereas in Le Parlement Belge, the Belgian government was the owner of the mail packet. And he says this, but the rule is not limited to ownership. It applies to cases where what the government has is a lesser interest, which may not merely not proprietary, that makes sense, but not even possessory. Thus, it has been applied to vessels requisitioned by a government, where in consequence of the requisition, the vessel, whether or not it is in the possession of the foreign state, is subject to its direction and employed under its orders. That would be the point I would make in relation to Lord Sumption's earlier question about whether direction of control of a private ship for sovereign purposes is good enough. On the following page at 508, Lord Wright says, this is towards the end of the first paragraph, in my judgment on the facts of the present case, the requisitioning of the Christina under the decree of June 28, 1937, gave the Spanish government a right or interest in the Christina, whether called property or not, which was immune from interference by the courts of this country. So then, again, we shouldn't be looking at this through property law, and there's no reference to possession there.
Is Lord Wright here not referring to a second head of adjudicated jurisdiction?
My Lord, he's referring there to immunity from execution, not two separate parts of adjudication.
Why do you say that?
Because this whole part of the judgment is dealing with immunity from execution. Basically, from halfway down 506 onwards, he's dealing with immunity from execution.
That's my question, whether that's right, or whether this is not in fact the counterpart of Section 6, subsection 4 of the statute, which casts the net wider in cases of adjudicated jurisdiction.
My Lord, I perhaps went too fast through the report, but if we go back to 506 and the first few paragraphs of 506, they're talking there about the rule that a sovereign cannot be impleaded. This is the third paragraph down. Yes. In cases where title to real property in the jurisdiction or suits to administer a fund, etc., etc. There he's talking about immunity from adjudication. And then he says, in the fourth paragraph down, this ground would by itself, subject to some questions to be considered below, be enough to entitle the respondent to succeed. But there is a second ground on which the writ should, in my judgment, be set aside, which is that claims to interfere with the property of the sovereign, that it claims to interfere with the property of the sovereign. So that's where he launches into immunity from execution. He quotes from the Parlement Belge, which is a case can only be about execution, and then the rest of the judgment up until the passage I just quoted to you on 508 is dealing with execution.
How does execution arise in this case? This was a claim by the owners to recover possession. Yeah. So on the face of it, it's not a case about execution.
On the facts, it wouldn't have got to execution, it's true, so long as they weren't prepared to adjudicate the competing interests in the property, and they weren't prepared to adjudicate the competing interests in the property because of the immunity.
I mean, doesn't the whole of this case, while very important, arise from what Lord Sumption referred to earlier, and I did, I think, too, the odd analysis, no longer perhaps shared, of actions in rem as being against a person separate from the actual owner of the or possessor of the ship.
My Lord, I think the
once you get into that conceptual difficulty, you're talking then about whether you are indirectly impeding the sovereign by suing the ship. But that doesn't really help us in the present situation.
There's a good deal of discussion of this by both my Lord, Lord Mance and myself in the Belhage case.
But of course that's
precisely concerned with the extent to which the jurisprudence about cases in rem is relevant in this context.
Well, the Belhage case was quite clearly about adjudication, certainly not about execution.
I mean, very odd if Lord Wright and Lord Atkin really embarked on something which wasn't relevant, didn't arise at all, execution. What they're dealing with is, can these proceedings go ahead against whoever is being sued? And since under the law as it was seen then, there was this possible dichotomy between the ship and anyone else, they laid down two roads.
They went down two roads, but and I guess the most that could be said is that one road might have been Overton, but they certainly had the different immunities in mind, the two different immunities in mind.
Well,
and that's the way that they've been interpreted.
It doesn't read as if as if the distinction in their minds is between adjudication on one hand and execution on the other. It reads as if the distinction in their minds is between a principle that you mustn't impede a foreign sovereign on the one hand, and a principle that you mustn't interfere with his property on the other. Okay. Now, that interference might be occasioned by steps taken in execution, but it might be occasioned simply by an assertion of ownership, which is what this case was about.
Well, if it can be read in that way, that still gives rise to the question, well, how should it be any different? How should the principle be any different when we're talking about execution?
Yeah.
If anything, it should be more robust when we're talking about execution.
Well, the difficulty is that it's only actually necessary to distinguish between the principles governing immunity from execution and immunity from adjudication. Once you apply the restricted doctrine to the immunity from adjudication, then you've got a divergence, which is what international law and subsequently UK statute law had to grapple with in the period after the Second World War. But at this stage, this was a question that hadn't really been resolved. Indeed, it was a point on which Lord Atkin and Lord Wright differed from the other three members of the panel. But the difference didn't actually affect the way they decided this case at all.
Whether or not it was a restrictive,
yes.
a restrictive basis. Certainly it didn't affect the way that Lord Wright and Lord Atkin looked at it. But again, that's the learning that we have on the requisite link.
Yeah.
You may say it's obiter in the context, may not be. But of course, when we come to the UN Convention, it's very clear that this is what they were basing themselves on to draft the relevant provisions of that convention in relation to both adjudication and execution. My Lords, it's interesting to take the Christine and then see what happened in the immediate aftermath of that in a Scottish case which was very much related. It's the next tab, and it's involving the ship El Condado. It relates to exactly the same Spanish requisition decree.
Page?
Page 159, I do apologise. You're paying the penalty for going paperless, I'm afraid. I'm sorry about that.
Sorry, I've lost you. I've lost you. Where?
This is the next tab in the authorities bundle
right.
at 159. Same requisition decree decided just after the Christina. And what this demonstrates, my lords, is that property for the purposes of property law and property for the purposes of state immunity is not the same thing. Because here, it was the Spanish government that was the claimant. And they were claiming damages resulting from the interdict that had been placed on the ship by the defendant owners. And they said that the defendant owners, rather ambitious submission, but they're saying that the defendant owners of the vessel were not entitled to challenge the lawfulness of the Spanish government's possession of the vessel based upon the requisition decree. And they said that that's the result of the Christina. The Court of Session rejected this because there can't be immunity from adjudication where the government is the claimant and the government's requesting adjudication. And so the court could inquire as to the lawfulness of the possession, and the court found that the possession was unlawful because the requisition decree could not impact upon ownership of a vessel outside of Spanish territorial waters. And so one can infer from that the possession in the Christina, which was accomplished in exactly the same way, was probably unlawful as well. The court didn't say that. That would have not been consistent with throwing it out on immunity grounds. But it's very clear from this case, when they did go to adjudicate the competing property rights, that the possession was found to be unlawful. So, despite that, the rights that were given by the Spanish requisition decree, even though they didn't have any basis in English law, were considered to be sufficient to constitute property of the state for immunity purposes, but it certainly didn't cut any mustard when it came to dealing with the actual proprietary interests in the ship when the claimant was the Spanish government. One could perhaps draw an analogy here with the rule of private international law against the enforcement of foreign penal, revenue and public laws. So in the Christina, you might say that that was about recognising the Spanish decree, whereas in the subsequent case, the El Condado case, that would have led to the enforcement of that decree. English courts won't enforce a foreign public decree, which had no impact upon property within the territory of that state. But for the purposes of immunity, they were happy to recognise it in the Christina. That might be a nice way of looking at the difference between those two cases.
Do we know when, where this ship was when on the 28th of June 1937, when the law took effect, or the 29th
It was in
of
the
June?
port of Greenock.
Well, that may make a difference, may it not? Because in the Christina, there was an argument that the Spanish decree should be ignored because it was an extraterritorial, purported extraterritoriality to expropriate an interest in the ship. And that failed primarily because the ship was not in the United Kingdom's territory when the decree took effect. But it looks as if the El Condado was in Greenock at the time when it took effect. So that your analogy with the principle that you don't enforce the public laws of other states or give effect to foreign law in relation to property situated in England would be correct, wouldn't it?
If the Christina... Sorry,
The Christina was requisitioned on the high seas.
Yes.
The El Condado was purportedly requisitioned in Greenock.
Oh, I see. And you're drawing a distinction between a ship being the property of
Well, it is a
floating
difference.
island of Spanish territory in the high seas and a ship being within the territory.
It's very well established that the British courts will not recognise foreign legislation which purports to alter the interests in property situated within the jurisdiction of the United Kingdom.
But my Lord,
that seems to have been the problem in the El Condado case.
Yes, but my Lord, whatever the Spanish government could lay claim to in Christina, They certainly weren't saying that they had title.
No, they were claiming an exclusive right of possession. And,
But the way each judgment reads in the Christina is that the only right they had and could claim was the de facto possession that had taken place once the consul had boarded and broken into the ship. So it wasn't put that way. I mean,
well, why was there an argument then about the extraterritorial effect of the decree?
in the Christina or in the
The Christina.
In the I don't believe there really was an argument about it. That there was just a concession that the Spanish government didn't have property in the vessel. And I think it's said, and we'll come now to the Dolphus Mead case, it's been said subsequently that Lord Atkin and Lord Wright were careful to extend the principle to control precisely because many of the requisition cases that were cited to them dealt with a situation where title had not passed, the ship was simply under the direction and control of the relevant government. And the Broadmain case is an example. So the Dolphus Mead case, it's at tab 9, page 186. And to our collective relief, it has nothing to do with shipping. The Bank of England here had a number of gold bars that had been confiscated by German troops from a French bank in Limoges, who was at the time holding them for a French company named Dolphus Mead. The gold bars had been recovered in Germany and then lodged with the Bank of England by the governments of the UK, France and the United States for safe custody pending their ultimate disposal. Dolphus Mead brought an action against the Bank of England claiming delivery of the bars. And the Bank of England applied to have the writ set aside on the grounds of the foreign state of immunity of France and the United States, and those two governments were later joined as defendants. Now, it was conceded in this case that ownership of the gold bars remained with Dolphus Mead. And we see that recorded at page 608 of the report, and Lord Porter's judgment. It's at page 212 of the bundle. The end of the first paragraph of his judgment, he says, for the purpose of the present appeal, the appellants are prepared to accept the view that the property in the bars remains where it originally was with the respondents. So, unlike the Parlement Belge, the state had no ownership interest. And, of course, the Bank of England also had possession of the bars. So, unlike the Christina, there's no de facto possession here on the part of the foreign governments. All that France and the United States had was the right to demand possession of the gold bars in a bailment context. We turn to El Jawitz's speech first, at 603 of the report, which is 207 of the bundle. You see at the bottom there, he sets out the principle stated by Lord Atkin in the Christina. And then after the quotation on the following page, he says this, my lords, I think it probable that Lord Atkin inserted the words or control in his second proposition so as to make it wide enough to cover those cases which had been cited to him in argument in which the foreign government had requisitioned or directed a ship without depriving the owners of their possession. This is, I think, merely an illustration of one of those interests, lesser than a proprietary interest or even than a possessory interest to which Lord Wright referred. There is, I think, no special doctrine applying to ships which does not equally apply to gold bars. At 606, page 210 of the bundle, the first paragraph, he says, and continues, the doctrine of immunity should not, I think, be confined to those cases in which the foreign sovereign was either directly in possession of property by himself or at least indirectly by his servants. For if it were so confined, the doctrine would not be applicable to the case of any bailment. I can find nothing in any decided case to support any such limitation. Then he quotes extensively from the judgment at first instance of Justice Jenkins, as he then was. And it's quite a useful analysis of the heart of the problem. So I'm going to read the whole passage. It says this, and he endorses the passage, and that's a passage that also is quoted in other cases. A foreign sovereign state, unless embodied in a personal sovereign visiting this country, cannot, so far as I can see, be in actual physical possession of property here otherwise than by its servants. Accordingly, if actual physical possession by a foreign sovereign state were essential to immunity on the score of possession by such state, immunity on that ground could only be claimed in respect of property in this country in the actual physical possession either of some personal sovereign or of a person who could be shown to be, in the strict sense, a servant of the foreign sovereign state, so as to make his possession that of his master, or else to be himself entitled to diplomatic immunity. The application or exclusion of the principle of immunity would thus be made to depend on nice distinctions respecting the particular mode in which a foreign sovereign state might happen to exercise dominion over property brought by it to this country in its possession or control. For instance, if gold were brought to this country by a foreign sovereign state to be applied in the purchase of goods for the public purposes of that state and placed in the hands of a servant of the state concerned to be applied in making such purposes in accordance with its directions, the gold would be protected by the principle of immunity on the score of possession by the foreign sovereign state, irrespective of any immunity from process that the servant might be entitled to claim in his own person. If, on the other hand, gold brought to this country by a foreign sovereign state for similar purposes was deposited by it with a banker or other agent for safe custody and disposal in accordance with its directions, the gold would at once become exposed in the hands of the banker or other agent to any adverse claims there might be, and the principle of immunity would afford no protection from actions brought by third parties against the banker or other agent for the purpose of establishing such claims. I cannot think it would be right to make the application or exclusion of the principle of immunity, based as it is on substantial reasons of policy, turn upon nice distinctions of this kind. So the crux of that reasoning of the trial judge, which was endorsed at the House of Lords, at least by Earl Jowett, is that courts should not be making technical distinctions based upon the nature of the interest that the foreign state asserts over the property in the hands of intermediaries. The critical thing is the purpose to which the property is put to as a sovereign use.
But isn't the point being made by Mr. Justice Jenkins that the reason why there's no difference between the case where the gold is in the hands of a servant of the state and a case where it's deposited with a bank is that in both cases the state has a right of possession, and in the first case actual possession as well. But this is a dispute, Dolphus Meag, about the right of possession, because actual possession was with the Bank of England, but what was being asserted and what was said to be the subject of state immunity was the state's right of possession as against its bailee.
Well, perhaps right of possession is therefore good enough, but how?
Yes, well, I think that is the critical point about all of these. There's a world of difference between a right of possession and some more general claim to control under the domestic law of the state. Because the right of possession is, for many purposes, quite possibly including state immunity, a form of, it's less than ownership, but it is for many purposes treated as equivalent. If you have a right of exclusive possession.
My Lord, in precisely on the facts of this case, we say that given the Republic can demand the shares to be transferred to its possession at any point in time, then that's good enough for state immunity.
I can see that it might well be if they'd exercised that power.
But my Lord,
but you say the mere existence of a power means that they have a right of possession even without exercising it. Do you?
I do, my Lord.
Supposing there was a general law which says any private property can be transferred to our state ownership with or without compensation. I mean,
there was such a law in England in September 1939.
Well, so would that mean that all property was now state property?
No, my lord. I mean, the other aspects.
Why?
of control-
Why not? Because the state could say, look, I'm sorry, you can't execute against this property. It's affecting something which we might next week be interested in having
Because-
transferred to us.
My lord, because there are other attributes of control which are present in this case, and which are important for the principle at stake. It's not simply an abstract right in general law to command possession because of some sort of.
So it's an
compulsory-
evaluative judgment based on a number of factors.
It's a number of factors.
Yeah.
But the idea that you don't get there unless it's actually exercised, that is not consistent with the cases, because it wasn't exercised in Dolphus Mieg. There was no delivery up on the basis of a right to immediate possession. They had it in the abstract, but they didn't exercise it.
But
And we'll see.
they had a right to immediate possession because the Bank of England was only a bailee for them.
My lord, they had the right, but at the time of the dispute,
They already had that right.
it already had that right.
This is an intensely practical decision, isn't it? Which, in order to deal with the obvious problem that property of a certain type, like jewellery and gold bars, is generally kept by somebody for you as a bailee in a safe or a vault, to treat that as disabling an immunity which would apply if the sovereign kept it in the basement of his own embassy would be absurd. But to extrapolate from that very practical approach about bailment to the proposition that any ability of a sovereign to call some piece of property into his possession therefore attracts the immunity even if it's never exercised is a big leap indeed, isn't it?
My lord, we don't need to make that leap in this case, and I'll come on to the precise manner in which we say we have control and interest over the shares in a moment. But it's not simply, we would not read this case, the Dolphus Mieg case, as standing to the proposition that an abstract power, that possession can ultimately be required by the state under general legislation would be sufficient.
It's not an abstract power, is it? Because as a bail-law,
No, I was referring to a hypothetical rather than.
Well, in this case, the
Yes.
bail-laws were the government, and they had an immediate right to call for possession.
Yes, but
It's not some prospective right in the
it's
arising
not
in the future.
prospective, my lord. But by the same token, it hadn't been exercised. They hadn't called for possession, so they had it in law. Yes.
But when you say it hadn't been exercised, they didn't need to do anything else in order to be able to call for it at once, whereas the existence of a right to take possession of shares, the first thing you've got to do is bring that right into existence by some legal step. Then you may be in a position equivalent to a bail-law if it's in the possession of someone else. But there was no preliminary step required at all in this case to enable the government to call for its bailee to surrender possession. The bailee was treated as possessing it on behalf of the government already.
It was by an operation of the law of bailment, but their lordships were very careful to say this case can't depend and can't be decided on the basis of technical aspects of the law of bailment, which may not exist in other jurisdictions because we're applying a principle of international law. So it wasn't decided on a basis as narrow as that, and that I can take you to the passages where they say, and I think I quoted them already, but for example, at page 605 of the report, page 209, about halfway down the page, Earl Jowett says, English law has incorporated the doctrine of state immunity from international law. It would be an unsatisfactory position if the extent and ambit of this doctrine were to depend on the special and peculiar doctrines of each jurisdiction in relation to possession. So really what the essence of the right that they were talking about was a contractual right to have the delivery up of the property. It's true that under the law of bailment, under English law, we would regard that person as having some sort of possessory interest because they have by operation of law, they have that right. But that's not the basis that their lordships decided this case. It wasn't on that technical ground. In fact, they all
My
said,
Lord will have to tell us why he thought that there might be a difference between English and Scottish law here. It's not entirely clear to me.
Or to me.
I'm relieved, my lord. I wasn't going to venture down that route.
But I think the point he's making is that you, if there is something equivalent to possession or very close to it, namely a right to immediate possession under a bailment, you shouldn't draw a fine distinction between situations where there's actual possession and where it's an absolute right to possession.
Precisely, my lord.
Yeah.
So with that far more succinct summary than I would be capable of, I'll move on. The Rakantula case at tab 10, facts are set out at 381 of the report, 230. 230 of the bundle.
Thank you.
So here you had funds on the account of the government of Hyderabad in Westminster Bank in London. The High Commissioner for Pakistan, Mr. Rakantula, received instructions from a representative of the Nizam of Hyderabad, who was the absolute monarch at the time, to transfer the funds to an account in his name. And that was done by the bank. The context for all this is that the Indian armed forces were in the process of invading the territory of Hyderabad. So that what happened was that Nizam later claimed the funds. India, in fact, gave notice it was going to try to get hold of the funds as well. And the question was whether Pakistan's immunity prevented adjudication. Viscount Simons quoted, again, Lord Atkin's two principles. We're at 394 of the report, 243 of the bundle. At 244 of the bundle, 395 of the report, about halfway down, he says that the action by the Nizam is calculated and intended to interfere with the title of Rakantula and his principals, the government of Pakistan, with their possession or control of their property. The important point here, though, is that title to the funds vested in Mr. Rakantula. He was the person in whose account the funds were held. So here the government of Pakistan had at most a beneficial interest. And at 396 of the report, incidentally, he says at the end of 395, I would deprecate fine distinctions in our municipal laws in the application of international doctrine. And this, again, is a theme that you see in all the judgments. At the top of 396, at page 245 of the bundle, he refers to Dolphus Mieg, and he says, I decline to accept the argument of counsel for the respondent that this conclusion rested upon any sacred principle as to the rights of bailor and bailee, and I should regard it as deplorable if the court, while accepting as a matter of comity the right of the foreign government to deny its jurisdiction in regard to valuables, yet rejected it in regard to a shows in action. Lord Reid, very similar points, and I can probably skip over them. He said at the bottom of 399 of the report, 248 of the bundle, Court of Appeal decided the action should not be stayed. They're of the opinion that even if the appellant was acting in his official capacity, he was only an agent, that he held the legal title to the money, and there can be no possession or control of a shows of action by anyone who does not hold the legal title, and that therefore there was no basis for Pakistan's claim to have the action stayed. And he said that's too narrow a view. At the bottom of the first paragraph, it appears to me that Pakistan had an immediate and direct right to sue the bank in its own name for payment of this money. So again, they don't have the right now. They have to go to court to recover. And in that sense, it had a legal title. It had full control over the shows of action. It's not an analysis that would really work under English property law, but good enough for immunity, because we're not applying property law. Page 402, halfway down the first paragraph, this is 251 of the bundle. I do not see any reason why the right of that state to claim sovereign immunity should depend on whether the bank account stands in the name of the state itself or stands in the name of its servant, agent or nominee. And we would add separate entity.
Well, separate entity, though, is not a servant, agent or nominee.
It could be a nominee, my lord, but you're right. He wasn't.
But this is an agency situation. I mean, why isn't this within the original category, which was discussed in, for example, Dolphus Meek and servant or agent, where they extended it to bailment. This was a servant or agent situation. Rahmatullah held the account for the government of Pakistan.
That's correct, my lord. He must have been an agent for the government of Pakistan.
So they just asserted their own contractual rights as unnamed principal.
That may be correct. That's not how it was characterised, but it would certainly concede that he must have been the agent of the government of Pakistan.
I'm not sure it isn't how it's characterised. If you look at Lord Reed in the middle of page 400, he says it's well settled that a principal, including an undisclosed principal, has a right to sue directly in his own name.
Yes, quite right. So undisclosed principal, yes, the right to recover the money on that basis was considered. My lords, then we get to the Australian case, and this is at volume 5, tab 33. And now I'm going to let Lord Briggs down because I'm afraid that the electronic numbers or the bundle numbers have been blacked out. 1, 2, 3, 4.
Thank you very much.
Clearly a conspiracy against Australians.
So where are we? Volume 5.
Bundle 5, tab 33.
Right.
In this case, the government of the Saudi Arabia had donated funds to the Australian Federation of Islamic Councils to assist with the development of Islamic schools in Australia. The funds were deposited on an account of the Islamic Councils, but the ambassador for the Kingdom of Saudi Arabia was a joint signatory with the president and the treasurer of the Federation of Islamic Councils. The Federation later insisted that the ambassador had surrendered control over the funds such that the Federation was able to deal with them as it wished according to its constitution. And we see that at the top of page 628 of the report. And then the judge made the following findings, and this is 2 paragraphs down at D. I'm satisfied that the monies the subject of the interest bearing deposit are the property of the Federation. The monies were a gift from the Kingdom of Saudi Arabia to the Council for a specific purpose. I'm also satisfied that whilst property and the monies passed to the Federation, it was a term or condition of the gift and of the deposit with the bank that control of the disposition of the funds was to be exercised by the ambassador and the Federation representatives jointly. The judge then asked himself, and you see this at the bottom of 630 of the report, he asked himself whether the claim of right, being only a claim to partial control of funds, the property of the council, is a claim subject to diplomatic immunity and common law. We don't need to read anything into the reference to diplomatic immunity because he actually applies state immunity, as we'll see. So at that page you see he refers to the Christina, he refers to Dolphus Mieg, he refers to Rahmatullah, he quotes Justice Jenkins' passage in Dolphus Mieg, and then over the page at 632, around about D, he says the monies after gift to the Federation were retained in the control, at least in a prohibitory sense, of the ambassador as representative of the kingdom. On any view, the proceedings in respect of control of those monies brought by the Federation raise a triable issue as to whether the ambassador has control of the funds in his official capacity for purposes relating to the interests of the kingdom he represents. There being such a triable issue, immunity arises, for if it did not, the kingdom would be obliged to either surrender its claim of right to the funds or submit to the jurisdiction. course, there's no question here of the Kingdom of Saudi Arabia having any proprietary interest whatsoever in these funds. All that can be said is that one of the signatories, so therefore who had partial control over the funds, was the ambassador. You go to the end of the final paragraph of 633 at G. The ambassador is one of 3 necessary joint signatories for disposition of the funds. He thus only has partial control. In my view, this does not negate the application of sovereign or diplomatic immunity. In Dolphus Mieg, the United States and France had partial possession. The remaining joint possessor was the United Kingdom, which does not have sovereign immunity. So we would say that goes consistent with the test, but goes further on the facts, because no conceivable proprietary interest of the state in the funds, but nonetheless they had partial control.
The description of the principle on your page 632 sounds very much like the you mustn't impede a foreign sovereign part of the doctrine, rather than you mustn't interfere with his property, i.e. the first limb.
Oh, I see.
Christina, rather than the second one.
My Lord,
and it appears to be so because of the nature of the issue in the proceedings.
Yes.
One sees that also in the form of the orders given on page 634, particularly the declaration in paragraph 3.
My Lords, you're absolutely right. This is an adjudication case. So it was disposed of on that basis. But again, we say the principles that arise from adjudication are necessarily able to be transposed to execution, with the caveat that the immunity is more protective and we apply a purpose test and not a nature test. My Lords, I'm going to skip over Belhaj because I suspect it's rather fresh in your mind about what constitutes an interest in the circumstances. I'm also going to skip over the Bankult case where we draw an analogy to the test of control that was applied by the majority in the Supreme Court on that occasion, determine whether or not a document was within a diplomatic archive. But we set out the relevant extracts at paragraphs 112 to 115 of printed case. I'll also, moving on to part 4 of my submissions now, I'll also skip over the UN Convention. We've set out the relevant parts of the travaux préparatoires in paragraphs 68 to 71 of our written case. And the simple point we make is that the common law cases dealing with possession and control have inspired both the approach to immunity from adjudication and immunity from execution. But the relevant extracts are set out in our written case, and I have nothing really further to add to that.
We are construing a UK statute here,
Yes.
in which the expression property is used without a special definition. One can see that if there was an autonomous concept of property in international law, that might be relevant background against which to construe the word property in a statute. But are you in a position to suggest that there is an autonomous notion of property in international law?
My Lord, there certainly isn't an autonomous definition of property, because ultimately property rights can only be conferred by municipal law.
Well, indeed.
But as we've seen from the lordships in the Christina, in the Rakhimtula, they're very careful to say that we cannot be approaching this through the lens of English property law. This can't be dependent upon...
What's the alternative lens? We've got to construe the word property.
The alternative lens...
In a UK statute.
Yes.
So if we don't look at property concepts as they stand in English law, where do we get the question, the jurisprudence or the inspiration about what property is in this Act?
We're not so concerned about what property is, but whether property is of. We're construing of. In other words, we're construing the link between property and the state.
We're asking ourselves, what is the property of a state?
Right, and so because we're looking at a link between property, there's no dispute that shares are property, for example, in this case. There's no dispute that a ship is property, etc., etc. What we're concerned about is whether there's a sufficient link between the property and the state to justify going to the next stage of the test. And my submission from the outset has been that we need to be cognizant of what the purpose of the test is, and the purpose of the test in the restrictive doctrine is to protect assets that are being used for a sovereign
The
purpose.
expression property of a state is referring to some kind of right that the state has in respect of property. If one was looking at this in any other context than an international law context, one would say that what those words mean is that the state has to have a proprietary interest in it. Now, you say that the word, and that derives from the word property and not from the word state. Now, you say that the word property in this context has got to have a meaning other than that which English law would give it. And I would like to know, what is the source, what is the jurisprudential source where we find what that meaning is, if, as you rightly recognise, property is inherently a matter of municipal law?
First of all, the English cases, in particular Christina and Dolphus Mieg, in particular Dolphus Mieg, I should say, but also the Islamic Council's case in the New Zealand Supreme Court, they obviously don't depend upon applying a proprietary concept to that link, because they didn't exist. So, again, I would take a step back. What functions does this test serve? And the function it serves is to ensure the property that is being deployed for a sovereign purpose is protected. So we're looking at a relationship.
These cases are all decided at a stage when the absolute doctrine prevailed and when the statute we're construing didn't exist.
Which, if anything, means that now, after the State Immunity Act, we should be even less concerned to keep it within the limits of those cases that were decided under the absolute doctrine, because under the absolute doctrine, if it's property of the state, end of inquiry, you've got immunity. That's not the case here. You only got immunity if it's being used for a sovereign purpose.
That's not quite the point that I'm trying to explore with you, which is what does property of X, it doesn't matter who it is, mean in an English statute, if not some kind of interest in that property recognised by some municipal law?
Means, as the courts have said, possession or control. And it's just a matter of construing how far control goes.
Isn't that an odd concept or an odd definition to adopt in the context of execution? If you were talking about execution, you can't execute against property simply because it's in someone's, if they owe you a debt, simply because you find property which is in their possession or control. What you're interested in is ownership. And so might we not gain some assistance as to the meaning of the word property from the context in which it's here used, as well as the fact that it's not embellished, as other references to property elsewhere in this Act are, with references to possession or control at all?
It's not embellished. It was embellished at one stage in the UN Convention, and then it went back to just simply using the term property of the state. But it's clear that that's what they meant. They meant ownership, possession, or control.
Well, I don't know. You have to show us the UN Convention and its history. If it's had fluctuating terminology, it's a bit difficult to accept that submission without a bit more. But getting back to the English, the UK, the Jersey, the English, or is it UK? It's UK statute, which is annexed to the Jersey order. We have the bare word property, and in the context of execution, my point is that's what you're looking at, some proprietary interest against which you can execute.
My Lord, I would be very reluctant to draw any sort of symmetrical parallel with the circumstances in which you can enforce an asset. And we'll come to this because that's...
Why? Because it's what the whole of this section's about.
Mm-hmm. But in circumstances where you're trying to enforce an asset which is in the hands of a separate entity, and the Hemisphere case, which is what we'll come on to, discusses, well, under what circumstances should you be allowed to enforce against an asset held by the separate entity in relation to a state debt.
Do you accept that if there was a judgment against the state of Turkey, it could not be executed against assets of a separate entity such as Botaş?
I would accept that, and I don't think there's any contradiction in going down that path.
Now, why is that so?
My Lord, if I could be permitted to park that until I get to the respondent's case, because that's the crux of their case. It's based on hemisphere. And I can go...
Based on a little more than that, but anyway, it is certainly among other...
But I certainly will come to it in great detail.
Okay.
So I'll move on to part 5 of my submissions, and this gets to the actual control and interest over Botaş's shares in TPIC and BIL, which is exercised by the Republic of Turkey. Just to show you where the findings have been made, on the record, not the authorities binding, but record, volume 1, at tab 9, page 185, you see here that the Royal Court makes 3 sets of findings. The first, this is paragraph 166.
I'm sorry, we're going to the record?
Yeah, the record at volume 1.
Volume 1.
185.
185, precisely. And so at... I'll just pause for a moment.
Thank you.
It's tab 9 at 185.
Yes, thank you.
So the Royal Court divided its findings into 3 parts. At 166, taking first measures which apply to Botaş, and then they set out the various measures there. The second part, at 167, measures that have an effect in relation to the shares, and then at 168, measures having direct effect on TPIC and BIL. We'll focus on the measures having direct effect on the shares, and we have set those out. We'll summarise them at paragraph 15 of our written case. It might be helpful to have that in front of us. And in paragraph 15 of our written case, we provide you cross-references to the Court of Appeal judgment, where they discuss these issues too. And of course, none of the findings were overturned by the Court of Appeal. So at A, we say this: the incorporation of TPIC and BIL was authorised by decisions of the Republic's Council of Ministers, i.e. its cabinet. As a matter of Turkish law, TPIC and BIL could not have been incorporated without the Council of Ministers imprimatur, pursuant to Article 58.3 of Decree Law 233. Now, one of the interesting things, as by way of background, is that in relation to TPIC, it was originally established as a Jersey subsidiary of a company called TPAO, Turkish Petroleum Corporation. And then, as an example of how this control is exercised, it was then transferred free of charge out of the formal ownership of the Turkish Petroleum Corporation into the ownership of Botaş. And we see that, we might not need to turn it up, but it's at the record at volume 9, tab 82, page 2447. And so we say that's an example of how the shares have been subject to this. 2447. And just to give you the references for your notes, the decision in relation to TPIC, to establish TPIC, is on the record, volume 7, tab 69, 1957. And for BIL, it's on the record, volume 8, tab 75, page 2025. What is said by the Royal Court at paragraph 128 of the judgment, at page 170 of the bundle, they say this: Botaş and TPAO needed the authority of the Council of Ministers under Decree 233 to incorporate the Jersey subsidiaries, and that is what was granted by the Council. The two decisions of the Council are consistent with that, in that they speak of TPAO and Botaş being authorised to establish the relevant company. The point B of paragraph 15 of our written case: as a result of this, and due to the operation of the Turkish law principle of parallelism, that's a Turkish doctrine of administrative law, a restriction was imposed at the date of incorporation such that the Republic, and only the Republic, has the power to change the ownership of TPIC and BIL, i.e. to require the shares to be held by someone other than Botaş.
Well, that's, do I understand it correctly, means only the Republic can instigate a voluntary, well, I call it voluntary, but a voluntary transfer by Botaş to somebody else. We know that under Turkish law, I know you say this is irrelevant, but the other side of the coin is that under Turkish law, apparently, these shares could be executed against.
I'm not sure that's conceded, but the point about the voluntary disposition or not voluntary disposition, it wouldn't have made much sense for the Republic of Turkey to try to legislate for how shares in a Jersey company can and can't be disposed. So the fact that these proceedings presently are concerned with an involuntary disposition, and that somehow doesn't affect the disposition of shares in a Jersey company, we say that's perfectly understandable.
That may reflect the reality that if you choose to set up foreign, or allow the setting up of foreign subsidiaries of one of your own subsidiaries, you accept the exposure to foreign creditors.
Well, Lord, another point on that is that the respondent accepts, as did the Court of Appeal, that if the Republic simply had a contractual right with exactly the same powers in respect of Botaş, then that would have been sufficient. And we say that surely the exercise of sovereign powers to create those privileges of control should be entitled to more protection than a mere contractual one.
Well, is that statement right as a general statement, that contractual powers would have been sufficient? It depends what the contractual powers are. Contract availment may be one thing. A simple obligation under a contract may be something different.
If the powers that we have, which we say put us in the position of being the de facto owner of the shares, where we have the privileges that one would normally associate with being the owner of the shares, if those privileges were simply stuck into a contract, it appears that the Royal Court of the Court of Appeal and the respondent accept that would be good enough.
Yes. Well,
As
but why?
Contract with the state, is it?
The contract between the Republic and Botaş in relation to the shares held by Botaş.
I see.
so you say that if the Botaş had entered into a contract with the Turkish state, under which it would agree, say, to appoint the Turkish state as their irrevocable agent to dispose of some of its assets, that would have meant that even before the exercise of those powers, there was state immunity against execution.
That's what the Royal Court of Appeal found.
But do you say that's right?
What I say is that one can't, if that is right, then one can't draw a distinction
I'd
with...
quite like to press you on this. Do you say it's right or not?
So long as that the same powers that we're advocating constitute control here are reflected in that contract, then yes.
And how would the powers be formulated? They would be undertaking not to...
Well, I'm going to get through the powers...
To change the ownership of TPIC and BIL.
Yes, but also, as we'll see, we have the Republic has complete control over who's appointed to the boards of TPIC and BI. Either those appointments come from the ranks of the Ministry of Energy, or the Republic has to approve a nomination by Botaş. So we have complete control over who sits on the board as well. Plus, and I'm moving through the various factors listed at 15.
Just before you leave this one, there's a slight difference in the language in your paragraph 15b about the consequence of parallelism, and the judgment at 167 2, Roman 2, because the Royal Court describes the principle as meaning that although it's still for the shareholder, that's Botaş, to effect the change, as I understand it, they have to get the authority of the Council of Ministers. Yeah. In other words, the formal power to effect the change remains, as one might expect, in the shareholder Botaş, but it would be a breach of the regime under which Botaş is established to exercise it without the consent of the ministry. That's how I read the judgment, whereas you put it in terms of there simply being no power at all as a result of parallelism in your case. Is that sort of an accident of language, or is there a real point here?
I don't think there's any difference in substance, because we've seen the way it happened previously in 2013 when the shares of TPIC came out of TPAO's formal ownership and went into Botaş's ownership.
How was it actually done in terms of
done by decision of the Council of Ministers.
I mean, no share transfer of any kind?
There's nothing on the record. I can take you to that decision.
I mean, transfers of shares in a Jersey company would be governed on the basis of their validity, would be governed by Jersey law, would it not?
My Lord, except that Botaş being a Turkish company, the Republic has powers over a Turkish company.
Yes, but let us suppose that without consulting the Council of Ministers, Botaş had in fact disposed of the shares of these subsidiaries in favour of a third party.
We'd accept that title would pass.
Well, and that's not easy to reconcile with the submission you've just been making, is it?
My Lord, but that would be done contrary to Turkish law.
I dare say, but the point that if you accept that it would nevertheless be effective, it rather suggests that Turkish law has no bearing on the point. Except, of course, as between Botaş and the Turkish government.
Lord, it wouldn't be effective simply because the lex situs is Jersey. So, and Turkey can't legislate for property rights in Jersey. But as we're seeing with the previous transfer, it's effective because Botaş is a Turkish subject. And it was effective because the transfer could take place under that power from one Turkish state enterprise to another Turkish state enterprise without consideration being paid.
Yeah. But I, going back to the contractual situation where you say there's been some concession, at the moment I find it difficult to see if there was a contract to the effect set out in Royal Court paragraph 167(2), why that would be of any relevance at all to the present situation. Simply be, as my Lord has suggested, is the position, some internal matter which might or might not be observed correctly, but wouldn't have any effect on the, in Jersey, or one would have thought international law eyes, the property in the shares. The property in the shares would be the Botaş's. It could deal with them. Whether it dealt with them correctly under Turkish law is neither here nor there.
Well, it's neither here nor there for property law purposes, but it is significant for immunity purposes.
Well, property in the relevant provision of the State Immunity Act must surely mean, I mean, you can argue about the definition of the kind of right referred to as property. It must be something which English law would regard as property as conferred by the relevant municipal law, in this case, the law of Jersey.
And there's no dispute that shares are property, but what we're concerned with is the relationship that's required between the state and that property for immunity to it.
But a proprietary right, as referred to in the Act, must refer to a kind of right, provided that it is recognised by whatever municipal law governs the relevant asset, in this case Jersey law.
My Lord, with respect, that's not consistent
possibly refer to Turkish law.
Yes, but that's not consistent with the Christina line of cases, where you weren't, the Lordships were very careful to say we can't apply English property law concepts to this question. Because in some jurisdictions there may be a contract with these rights in place. Fine. In other jurisdictions it might be dealt with by general legislation. I mean, take an example, a certain French company has to deal with uranium because they run nuclear reactors. Does it matter, does the French state retain legal interest? Probably not. Do they have a beneficial interest? Probably not, but those two would be fine. Do they have a contractual interest? Maybe in some circumstances that would be fine. But if the French state tried to regulate the use, disposal and acquisition of uranium through general legislation, are we saying, well, that's not sufficient, that's not sufficient control? It's a regulated substance, there's all sorts of restrictions on how it's used, but because it's not in a contract, because they don't have formal ownership, a private creditor can enforce against the uranium.
So is it enough to enable a company to avoid execution against its assets that it's entered into a contract with its own government not to dispose of them or part with property in them?
My Lord, if it could be ascertained from that contract,
Provided that was done, I think you would say, for sovereign purposes, as far as the state was concerned, it would be enough, would it?
my Lord, yes, because there's no dispute about competing proprietary interests. The net result of all this is that simply that asset, if it's being used for a sovereign purpose, won't be able to be enforced against
is it
today.
the use of the asset for sovereign purpose or the purpose for which this contract is entered into? I mean, let's suppose the Turkish government decides that in order to protect the economy of Turkey against execution of assets internationally, it's in the interests of Turkey to stop this. So they enter into contracts with large numbers of companies with assets outside Turkey, under which the companies undertake contractually not to part with any interest in those assets without the permission of the Council of Ministers. You say that that is enough, do you, to make all of those assets immune from execution?
No, my Lord, because it's only half the test. The conclusion at this point, at that stage of your analysis, makes no difference to anything.
Well,
it's only
the half that you say is left out is about the sovereign purpose.
Yes.
So you say it's got to be the sovereign purpose applies not to the reason why the state has acquired this particular contractual right, but to the use which is made of the asset pending the exercise of that right.
Precisely, and that is the settled law of how you apply section 13.2.4. Sorry, 13.2b with subsection 4. It has to be the use to which the property is currently being put or intended to be put. Not the transaction that gave rise to the property right or anything in the background. It has to be the use today that property is being put to. And of course, that's going to be a very narrow test at the end of the day. So yes, you can imagine a malevolent state passing legislation or entering into contracts with all of its state enterprises, but it's not going to achieve anything unless a court independently finds that property is being put to a sovereign use. Just to give you the reference, though, to the Court of Appeal's reasoning on this contractual basis, which they said is entirely different and would have been good enough. That's at paragraph 133 of the Court of Appeal judgment, which is at tab 2, page 73.
Which subparagraph should we be looking at? All of them?
I don't propose to take you to it now, but just to give you the reference, that's where they're saying it was a submission on the part of the appellants that a contractual right would have been good enough, and this is the same as what we have.
So I'm looking for the reference to contractual rights.
133, is it? At the bottom, yeah.
Okay.
This is what the Court of Appeal says. A contract is something that gives to a party a right to seek enforcement, if necessary, through the courts directly against the other contracting party. In the present situation, the entitlements which the Republic has over TP and Bill relate to the activities and direction of these companies, but not to the shares. That can't be right, because we're just going through now the various aspects of the control that the Republic unquestionably has over shares, and that's not the subject of any controversy before this court. It's very difficult to understand the point they're making. But the respondent concedes the contractual interest would be sufficient, and they do that in their written case at paragraph 85 and 190.1. So just to get to the end of my list at paragraph 15 of the various aspects of control, and I apologise, I've been flying through this. I've talked about the directors of Bill and TPIC at points E and F, and the final one, G, any change to the share capital of an overseas subsidiary of a state enterprise, such as TPIC and Bill, requires the consent of the Minister of Development and the Under-Secretariat. So the point we're saying is that under general Turkish law, under a special regime created in relation to these assets, the substance of it is that the Republic of Turkey is effectively exercising the rights that one would typically associated with an owner of the shares. Has the right to appoint the directors of the company, has the right to control any disposition or acquisition, transfer, etc. of the shares, has a right to approve any increase in share capital. Now, what the respondent says is that, well, that's all very well, but unless you actually exercise those powers, then there is insufficient control. But, my lords, that's contradicted by the cases we've seen. In the Islamic Council's case, it was only the background right of the Saudi ambassador to control the use of the funds as a joint signatory on the account that was held to be sufficient.
But I find the nature of the action quite difficult to follow there. There seems to be a claim for a declaration that they were the owners of the bank account. In other words, they seem to be claiming we are absolutely entitled. And in answer to that, it was pointed out by the bank, by Westpac, that the ambassador had an actual veto on use of these
Had
funds.
a veto, my lord, but there was no question of the Saudi state having any residual proprietary right in the property.
But
They had gifted the property.
But it wasn't an interference with property case. This is not how the judge describes it.
It was an interference with
adjudication of an issue
Yeah.
which would require the Saudi state to be impleaded
Yeah.
for its ambassador.
It was an adjudication case, you're quite right.
It doesn't, as I read that case, it doesn't really advance us at all in the issues which we're concerned with here.
Well, my lord, that would put us in the ironic position that if there was some adjudication to be had, that would stop because of immunity, and then you'd never get to the point of having liability to enforce against the asset. So it's the reason we say immunity from...
Well, unless you've got a judgment from another court with wider jurisdiction, which is the context in which these execution cases tend to arise.
But, my lord, you can't have a situation whereby your immunity from execution depends upon the prior situation in relation to adjudication. Because as we see in this case, it can arise in an entirely different context.
Here the fact is that there was no immunity from adjudication because matters were organised in a way which involved setting up a separate entity which is on the face of itself liable on its contracts, full stop. That's a commercial matter. So you're then asking, is there some immunity in respect of execution? And for the first time, the state is said to be involved.
Well, yes, and to be precise, there was no immunity from adjudication because there was consent to arbitration. But, my lord, it's a...
Well, I think it'd be a bit difficult to say that Botaş had immunity quite apart from the consent to arbitration. It entered into commercial contracts.
I suspect you're right. But to go back to a more extreme example, there may well be no immunity from adjudication in relation to a contract for the sale of fighter jets. We look at the nature of the test. Private parties can enter into a contract. But once it comes to execution against those fighter jets, you apply an entirely different approach. Is that fighter jet being used for a sovereign purpose? Probably. Does the state somehow exercise control over that fighter jet? Well, you would hope so. And so the approaches are very different. And a very important principle of state immunity, and this was the part of the paragraph of the ICJ decision that I was going to bring to you, is that one has to approach these things differently. An answer that you get from adjudication doesn't get you to the right place for execution.
Well, your fighter jet example is a case of a claim against the state. You get a judgment against the state for breach of the contract. You then try to execute against the assets which they failed to sell. It's a rather different.
My hypothetical is based on the fighter jets being owned by a state enterprise. And there are many of those that the state enterprise construct.
I think you suggested earlier, and I think you're making the same point now, that if the fighter jets were not owned by the state, but they were owned by a separate entity, that wouldn't actually need to be a nationalised entity, any arms company. They would be immune from execution of a judgment obtained against the separate entity because they were destined ultimately for the state.
Yes. And one applying this control test, I mean, again, it's where we're talking about hypothetical, but one would expect that the state would be exercising control over the use, disposal, acquisition.
Well, the state would be entitled to delivery ultimately when they were completed.
Yes.
Of the aircraft. But I mean, if you take the classic example of boots for the army, which are where there's no immunity against adjudication, I think your submission is that the unsold boots which it was proposed to sell to the French army would be immune from execution even though they hadn't yet been, simply because there was a contract in being under which the French army was entitled to have them in due course.
My Lord, you're going a little bit further than I think I need to, because our submission here is that the assets are currently being used for a sovereign purpose. So whether or not, if they're intended in the future and that doesn't seem to be borne out by the facts or whatever, we don't need to decide. But if one could imagine that if the boots are about to be put on the shoes of soldiers, that may well give rise to a protection from immunity at that particular point in time, if they're about to put on the boots in the trenches. In a situation like that, they may be protected.
No, I mean, one's envisaging that property hasn't yet passed out of the hands of the bootmaker.
My Lord, should that make all the difference in this context? Because again, we're not determining property rights. We're not judging that the state enterprise or the state or someone or the ultimate purchaser has property in these things. What we're judging is whether or not there's a sufficient interest or control to give rise to a protective immunity. But anyway, going back to the fact that they haven't exercised, that this is what the respondent says, we haven't exercised these powers in relation to the shares, but in relation to all these cases that we dealt with, there hadn't been an exercise of the power. Dolphus Mieg as well, it was a background power that you had under general law. There was no, in Rakhine, Pakistan had not exercised control over the funds at that particular point in time. It was sufficient that they could.
But there is this difference, isn't there, between those cases and this one? The powers in the Dolphus Mieg case and in the one that follows about shows in action could be exercised directly by the state or its agent, if he's the High Commissioner or whoever it was in the bank account case, against the bailee or bank, with no intermediate requirement to go through a separate entity. As I understand it here, is why I raised that question about whether it really was a power of the state to transfer these shares. All the powers of control, all the rights to insist on providing consent, in this case, operate as between the Turkish state and Botaş, and the state says to Botaş, do this, and Botaş does it. The state can't act of its own in relation to these shares, can it? Not in a way that would have any effect. Bearing in mind that the law which governs whether anything done in relation to these shares has any effect is Jersey law.
My Lord, it's certainly true that to accomplish the final disposition, it would require acts on the part of Botaş. Yeah. But we've got an example of this happening. If we go to the record at Volume 9, at tab 82,
Give me a page.
Page 2447. 2447.
Decision, yes.
And this is the decree that led to the transfer of TPIC shares from TPAO, the Turkish Petroleum Company, to Botaş. And we see on 2448, Article 2, the shares of Turkish Petroleum International Company belonging to the Turkish Petroleum Corporation
Shall be transferred.
shall be transferred
Yeah, but by
to
whom?
Botaş, free of charge.
By whom?
Well, my lord, obviously they have to come out of somewhere and
by
one entity and go into
By
another.
TPAO, presumably.
Yes.
Sorry?
By TPAO, presumably.
Yes, but this
Not
is
by the state.
Again, this is a direction, an order to TPAO.
Yeah.
You must transfer these shares to Botaş free of charge as soon as possible.
It doesn't say be and are deemed forever from here on in to be the property of Botaş.
It doesn't say that, my lord, because it can't, because
If
they're in Jersey.
If TPAO had said shan't, the result would have been, no doubt, the exercise of certain legal rights as between TPAO and the Turkish state in Turkey. But until something further happens, there would have been no change in the proprietary interests recognised by Jersey law.
My lord, if the Islamic Federation had done something with the funds, again, there wouldn't have been any change. The funds are still owned by the Federation. It's just the potential of the state to exercise control over how they may have been deployed. That's all that was at stake there. So interest, again we say that it can't make all the difference that if the powers we have were memorialised in a contract, that would somehow turn the tables, that general legislative powers should be entitled to more protection than simply private law powers in a contract. What did the court say below about the test? This is part 6 of my submissions. Well, they said you needed to show absolute control on a day-to-day basis. And you find that on the record, volume 1, tab 9, page 191 at the Royal Court level, and it was upheld on the Court of Appeal level at paragraph 131 of the judgment on the record at volume 1, tab 2, page 73. Now, my lord, that does give rise to a contradiction in a sense, because if you accept that control is sufficient, and the reality is if one branch of the state, such as a ministry, exercises day-to-day control over the asset of a separate entity, then that separate entity may well not be considered to be separate. So if the control test is going to work in this situation, it can't depend on day-to-day control. And it would lead to the situation whereby, in my fighter jet hypothetical, you could enforce against the fighter jet because the state, if the fighter jet's formerly owned by the state enterprise that constructs it, the state's not going to be in day-to-day control. It's certainly going to have control as a matter of the general legislative powers over military hardware, but it's not going to be in day-to-day control of that fighter jet. So it places a bar which is much higher than the bar that was than the test that was constructed in the common law cases. And of course the reality is all public property is managed by someone, whether state officials, government departments and state enterprises. And whoever's managing that property will be exercising day-to-day control. It doesn't really make any difference if the property is being managed by a particular state department or a separate entity for immunity purposes. Of course it does matter for when you execute against that property. We'll come on to that after lunch, but it doesn't matter for immunity purposes. What matters for immunity purposes is that the thing is being used for a sovereign purpose. And of course, if we look at the cases, in Dolphus Mig, it was the Bank of England that had day-to-day control of the asset. It wasn't France, the United States, the United Kingdom. It was sufficient that they had a theoretical right to demand possession. Again, in Rahim Tula, it wasn't the government of Pakistan was exercising day-to-day control of the funds. If anyone, it was Mr. Rahmatullah. The Islamic Council case, it wasn't the Saudi ambassador who was exercising day-to-day control. He had never exercised that control, or at least in relation to the dispute. And the Court of Appeal at paragraph 130, this is at page 73 of the record, it distinguished Dolphus Mieg and the other cases on the basis that the state could itself effect immediate recovery of what is its own direct property. And they said that the position of the shares is different because they'd never been the property of the Republic. But once again, my lords, it was accepted in Dolphus Mieg that ownership of the gold remained with Dolphus Mieg, so the foreign states didn't have property. In the Christina, the vessel had never been the property of the Spanish government. In Rahmatullah, it was Mr. Rahmatullah who had title to the funds, not the government of Pakistan. And in the Islamic Council's case, it was Saudi Arabia who had gifted the funds. So they had no proprietary interest left in the funds.
In Rahmatullah, it was Pakistan which had the right to the funds because Rahmatullah was their servant.
That's not. I certainly accept that would be a way of looking at the situation, but I think the way that the interest was described was a beneficial interest. But you're quite right that if the ambassador is the servant of an undisclosed master, that would have applied. But in the other cases, at least, there was no question of ownership. At the time the immunity was being adjudicated, was vested in the foreign state, and that didn't matter. So that way of distinguishing the cases, I'm afraid, just doesn't work. The other ground was that the alternative ground was that there could be a legal, equitable, or contractual interest. And you see that at paragraph 190 of the Royal Court's judgment. That's at page 192 to 193 of the bundle. And they said that it has to be some interest which has a legal basis, such as a legal or beneficial interest, or perhaps some contractual interest. The Court of Appeal came to the same conclusion, paragraph 118, it's page 69 of the record. But then it really doesn't engage in any analysis of what the interest is at all. And if we perhaps turn up the Court of Appeal's judgment at page 73. They say this: turning to the degree of interest which the Republic may be said to have in the shares, once again we see no reason to disagree with the Royal Court. We consider that the Royal Court was correct to recognise that the Republic has no legal, equitable, contractual interest in the shares, and that such indirect interest that it has through its ownership of Botaş is equally true of every other asset of Botaş, and indeed every other asset of every other Turkish state enterprise. We've already said that the powers which the Republic has in respect of Botaş are no different in character to those of a 100% shareholder. That applies equally when considering whether there exists a sufficient interest to justify sovereign immunity. But of course, they're looking at the wrong thing there. They're looking at the powers we have over Botaş and not the powers that we have over the shares. And the floodgates argument, which is again deployed there, again doesn't work because a finding halfway along the text that this is property of the state does not have any normative consequences. As I've said before, it has to be for a sovereign interest, a sovereign purpose. And then, as I said before, at paragraph 133, they say that a contractual right would seem to be different, but again, we question whether that would make any real difference in the circumstances.
Would that be a convenient moment, Mr. Douglasson?
My lord, it would.
Well, we look forward to hearing the continuation of your submissions at 2 o'clock.
Thank you very much.
We're rising at 3 today and giving you the extra hour tomorrow afternoon, if necessary.